Good morning, good afternoon, good evening, depending on everyone's time zone. Welcome to Panel 2, Governing the Climate and Environment at 11th Annual Cambridge International Law Conference. It is my pleasure to introduce your chair for this session. Professor Mary-Claire Cordonier-Segger is an affiliated fellow at the Laurel Path Center and Leverhulme Trust Visiting Professor in the University of Cambridge with the Bennett Institute for Public Policy, the Center for Environment, Energy and Natural Resources Governance, and other partners. She also serves as Senior Director of the Center for International Sustainable Development Law in Montreal, Executive Secretary of the Climate Law and Governance Initiative with the United Nations Framework Convention on Climate Change in Germany, and a full professor of international law for the University of Waterloo in Waterloo, Canada. She is a law fellow and director of studies for the LLM and MCL at Lucy Cavendish College. Without taking more time, I hand over the floor to Professor Segger.
Thank you very much, Tuba. Thank you, and indeed, good morning here in Cambridge for the next hour. It's a great pleasure to chair this Governing the Climate and Environment plenary panel of the 11th Annual Cambridge International Law Conference on strengthening global governance through international law, challenges and opportunities, which is hosted by our brilliant editors-in-chief, conveners, and other leading graduates from the Cambridge International Law Journal. We have a fascinating panel here for you. I will make only a few brief remarks before turning over to our panelists. First, of course, just to point out that in 2022, all countries are facing critical global challenges, which will define the next decades, perhaps centuries, of our civilizations on this earth. The risks are real, and the science which interprets them is well recognized. For years, even as globalization gained speed, delivering equivocal benefits to millions, we have been warned of emerging vulnerabilities. Scientists and others in the World Health Organization circles underlined serious risks of a global pandemic, now a reality as we respond and be in recovery from COVID-19. Scientists, journalists, and others in nature conservation circles, including the Convention on Biological Diversity regime, have highlighted the risks and realities of a global biodiversity crisis, with thousands of entire species, their natural habitats, and their ecosystems on the brink of collapse due to our development choices. Meetings this year are seeking to set a new strategy in place. Students have joined scientists and others in climate action circles, including the UN Framework Convention on Climate Change regime and its COP26 that was hosted earlier this academic year in Glasgow here in the UK, underscoring the risks and realities of the global climate crisis, with extreme weather events increasing, glaciers melting, sea levels rising, corals bleaching, droughts and desertification spreading famine, and humanity's capacity to adopt and implement sustainable energies, carbon negative infrastructure, technology and lifestyle transformations, and nature-based solutions in time still very far from certain. When countries celebrated the passage of the Paris Agreement on climate change under the UNFCCC in December 2015 in Paris, France, and its rapid entry into force 1 year later in Marrakesh, a certain sense of constrained optimism permeated the plans of government authorities, international organizations, and business communities, even our academic and civil society circles. However, implementation of the Paris Agreement is not just an environmental or economic challenge. It is a development challenge, responding directly to the world's sustainable development goals. Concluded at the UN in September 2015, predating the Paris Agreement by merely months, the 17 SDGs and their 169 associated targets for implementation recognize in SDG 13 on climate change that the UNFCCC is the key forum to coordinate global responses to climate change. In the SDGs, ambitious targets also cross a wide range of legal and policy challenges implicated and impacted by climate change, from SDG 2 on zero hunger or 3 on health, to SDG 6 on securing access to clean water, or 7 on affordable and clean energy, or 14 and 15 on life below water and life on land, not to mention, as this conference, I'm sure, will be underlining, SDG 4 on quality education and SDG 16 on peace, justice, and strong institutions. The SDGs may be soft law, aspirational voluntary targets adopted to facilitate more coordinated international and domestic action, but a circle of international treaties and organizations are struggling to meet each target. National progress is monitored, not just through the country submissions of the voluntary national reviews at the United Nations, which have been underlining the importance of high ambition, carbon neutrality, markets, progress on nature-based solutions, disaster risk reduction, and resilience, loss and damage, and robust climate change legislation and dispute settlements to implement the Paris Agreement in a manner that helps to achieve the SDGs. Not just these VNRs are relevant, but so are the reports and the monitoring and the dispute settlement and the finance systems, among many other mechanisms in the international treaties that back the Sustainable Development Goals. We have been trying our very best to implement the Paris Agreement, not the least with the progress that was made in Glasgow earlier this academic year. However, and as we are seeing, there are pitfalls and plateaus. National experiences to date offer cause for both cautious optimism and also increasingly profound concern. In essence, civilization has reached a crossroads with the global economy, nature, and humanity depending on ambivalent capacity for compliance with our climate and other sustainable development commitments. What I'd like to do here in this panel today is have a chance to hear from leading scholars from around the world whose papers have been successful in the competitive process, the scholarly review process for this particular upcoming conference, on some of their views on ways to be able to solve the climate crisis and all associated environmental and social crises through governance, through international law. And I think that we are truly privileged to have an extremely rich and diverse set of papers to hear from today. So I'm going to introduce each panelist as they speak, and I will start by introducing Santosh Anand, the Assistant Professor of Law, Alliance University, Bangalore, India, whose paper is titled Modified Continuity, International Criminal Law and the Vision of Ecocide. Please go ahead.
Thank you. So I'll just share my screen. Is it visible? Okay. So in this paper, I'll be specifically dealing with the recent definition of ecocide that the independent expert panel, which was set up by the Stop Ecocide Foundation, had recently made public. So this definition of ecocide is meant to provide a basis for state parties of the Rome Statute of the International Criminal Court to negotiate and eventually perhaps adopt as a fifth crime within the Rome Statute, which would be in addition to war crimes, crimes against humanity, genocide, and crime of aggression. So the hope is that this brand new crime would be included in the Rome Statute, and the object of this crime would be criminalization of harm to the environment or damage to the environment. So before really getting into the contents and the elements of the precise definition which has been proposed, it is useful to sort of put that in context in terms of what is the status of criminalization of environmental harm in international criminal law, and specifically Rome Statute, before this new proposal or initiative has been taken. So whether the question is Rome Statute criminalizes in some form harm to the environment or damage to the environment at this stage. So this specific provision we have in Rome Statute, which is part of Article 8. And this particular provision actually criminalizes a form of harm to the environment. but then it appears as part of the provision in a very specific way. So as you can see from the text of the provision, what is being actually criminalized is intentional launching of an attack with the knowledge that this particular attack will cause incidental loss of life or injury to civilians or damage to civilian objects. And then the relevant part appears in the form of or widespread, long-term, and severe damage to the natural environment. And then it is further qualified with the following, that which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated. So with all of these qualifications and all of this limits of context in which this particular harm to the environment, natural environment appears, limits severely the extent to which the environment is the object of protection in this provision, which is already part of the Rome Statute. Now, if we look at the relevant issues or problems with this specific provision from the point of view of protection of environment, the first problem is that the qualification of widespread, long-term, and severe damage is not defined specifically. These individual terms have not been defined anywhere in the text of the Rome Statute or elements of the crime which complement the Rome Statute. So that's a first problem, because that leads to lack of clarity in terms of the extent of damage to the environment, which is criminalized. So if we have a specification in terms of widespread, long-term, and severe damage to the environment without the details of what that really means, what widespread, long-term, and severe means, so that severely limits clarity with respect to this extent of damage. Now, the second problem is that such a damage has to be clearly excessive in relation to the overall sort of military advantage which is anticipated. Now, the protection of the environment in this provision is clearly contingent upon access to sort of military advantage, which is anticipated here. If there is reasonable military advantage which is anticipated, then environment can be damaged without problem. So environment appears secondary in the overall consideration of the provision. Now, this clearly excessive damage further has to be done with the knowledge and intent, as opposed to, say, the state of mind, which could perhaps be just negligible, negligent, or reckless, or willfully blind. Now, those states of mind, invariably it would appear result in graver forms of damage to the environment. And those are specifically excluded from this provision. And finally, the most obvious limitation of this provision is that this is confined to the armed conflict. So outside of the context of armed conflict, this provision has no relevance. Now, this was further complemented by the Office of the Prosecutor with her policy paper in 2016. She came out with a policy paper articulating her choice of prioritization of certain cases. And as part of that, in gravity calculation, assessment of specific crimes, which would form the basis for the prosecutor's decision to take up investigation in a particular situation, that assessment of gravity would have included as an incidental element destruction of the natural environment. So this was meant to be done with the use of two methods in two forms. That those core crimes would be prosecuted if they were committed by means of damage to the environment. That would be the first mode. Or the second one would be that those crimes, core crimes, would be prosecuted if they result in the destruction of environment, but then it was further qualified in this particular form, that impact of the damage would be in fact assessed in light of, among other things, the environmental damage inflicted on affected communities. So again, as we see, the protection is only incidental. And here also concern for environment comes only as a secondary sort of consideration, the primary object of which is to protect the communities or civilians. Now, finally, coming to the present definition that the independent expert panel proposed, which was composed of 12 international law experts from diverse backgrounds. Now, this definition has been extended to, is proposed to be extended to the peacetime situations as well, and would not be confined to merely conflict situations. And then the advantage that this provision has, that it goes on to not only define these individual qualifiers in terms of severe, widespread, or long-term damage to the environment, but then it also institutes a particular qualification. So here, severe is the common qualifier. Every damage has to be severe, but then along with it, either widespread or long-term damage would do. So this effectively broadens the scope of environmental damage that would be covered by this particular provision. Had it been the case that all these three different elements had to be there together, then a large chunk of damage to the environment would have been excluded. So this is a net sort of improvement upon the existing framework of law. But then the problem is that this, these set of qualifications are further qualified by this unlawful or wanton acts qualifier. So the damage to the environment must not only be severe and widespread or long-term, but they have to be subject to this further qualification of the acts being either unlawful or wanton. So as we know, most of the acts which damage environment happen to be lawful. So that way, most of the acts would not fall in that category. And that's how the term wanton becomes more important and way more significant. And then when we look at how wanton has been defined, there things get a bit more trickier. So the panel has chosen to define wanton in following terms: that acts when they are undertaken with reckless disregard for damage, which would be clearly excessive in relation to social and economic benefits anticipated. So again here, instead of anticipated overall military advantage, what the protection of environment has been subjected to is anticipated social and economic benefits, which is unqualified. So it has, the panel has not gotten into a sort of critical assessment or reflection on what would social and economic benefits constitute, but it is an unqualified social and economic benefits which excuses all sorts of damage to the environment, even if they happen to be severe and either widespread or long-term. But if all such forms of damage to the environment happen to provide sufficient social and economic benefits anticipated, then all those damage to the environment would be excluded from the purview of this definition and continue to be lawful. Now, so comparatively then, what does this particular definition of ecocide and hope that this forms a basis for a fifth crime in Rome statute qualitatively add to what we already have in the Rome statute or elsewhere in prohibition regimes like IHL as well? What does it effectively add? So in perpetuating this contingency of protection of environment over like lack of, say, sufficient social and economic benefits in this particular instance, or anticipated overall military advantage in the context of armed conflict through the instruments of IHL, it appears that the independent expert panel did not make new grounds or break new grounds and add, you know, added in qualitative terms any substantive change that way, because most of the environmental harm that were covered as of now would be covered even in with the use of this definition as well. And how it is that the panel went on to explain and justify its choice of this particular definition, and specifically making the criminalization dependent on the specific social and economic benefits. So the IAP was of the view that activities that are legal, socially beneficial, and are done in operated in a sustainable way to minimize impacts that nonetheless cause severe and either widespread or long-term damage to the environment. In view of the IEP, they might not be illegitimate or even undesirable. So this is how the IEP chose to explain and justify its choice of the definition, but it also further added the policy consideration, practical, pragmatic consideration, which was that if it if it did not choose to use a word like wanton, and that would have had more symbolic effect, going by the fact that ICC anyway cannot prosecute large number of cases because of institutional constraints. The definition was anyway going to have primarily symbolic effect, but even that symbolic effect is undermined by use of this particular terminology called wanton, and the IEP justified that by saying that the chances of state parties adopting this definition was higher if such an element was incorporated. It would not have been inconvenient to the state's parties. So this is where we are. So IEP definition does not break new grounds effectively. Thank you.
Thank you very much, Mr. Professor Anand. I will now call upon Dr. Carlos Soria Rodriguez, who is Marie Skłodowska-Curie Postdoctoral Research Fellow at the University of Jaén, and has a paper entitled Marine Renewable Energy Technologies in the High Seas, Challenges and Opportunities to Strengthen International Environmental and Renewable Energy Governance. Dr. Carlos, the floor is yours.
Thank you very much. I hope my screen is visible.
It is, and that's a fascinating desktop.
Yeah, many things. Working on many things. It should be the presentation ready.
I think so.
I will open again. So is it visible?
Yes, it is. Thank you.
Sorry for that. So good morning from the south of Spain, from Jaén. I will be talking about the governance of marine renewable energy technologies in areas beyond national jurisdiction, more concretely in the high seas. So first of all, I would like to say that this is a work in progress within a Marie Curie project. And the objective of the project is to provide answers to the regulatory and governing challenges for the deployment of marine renewable energy technologies in areas beyond national jurisdiction, as well as advancing and strengthening the applicable regulatory and governing framework. But the objective of this paper and the presentation is shedding light on two regulatory and governing challenges related to security and the protection of the environment, and that we have to take into consideration before massively deploying these technologies, as well as exploring alternatives that contribute to strengthen the governance of these technologies in these spaces. Before that, I will provide a brief introduction to what is marine renewable energy and what are the areas beyond national jurisdiction. So, as you know, the areas beyond national jurisdiction comprise the 64 of the global ocean. And in the picture at the left, you can see in dark blue the high seas, that they represent almost half of the planet and 2/3 of the ocean. Why are these important? They have an unparalleled potential for the use of technologies, because we can get energy security, also because it's important for the competitiveness of the states. And we can also fight against climate change through the use of these technologies in these spaces. As I was saying, it's comprised by two maritime spaces, which are the area and the high seas. Below you have the definitions provided in UNCLOS, which stands for the United Nations Convention of the Law of the Sea. And the second concept is the marine renewable energy. So the Secretary General of the United Nations defined this as all marine-based renewable energies, including wind. there are 4 types of marine renewable energy sources: offshore wind energy, ocean renewable energy, geothermal energy, and bioenergy derived from marine biomass. The 2 first, offshore wind energy and ocean renewable energy, are the most deployed, and because of the push, the political push, plus also the technological development, they have been mainly developed in areas within national jurisdiction, but the technology and the need to get clean energy, and in order to fulfill the Paris Agreement, which requires to foster the use of renewable energy, is pushing the development of this industry farther from the coast. So what I did is to provide the introduction and the structure of the paper, and this presentation is the following. I will briefly explain the regulatory framework and these 2 challenges for the governance of these technologies in areas beyond national jurisdiction. Once I do that, I will provide the conclusions of the analysis of how UNCLOS, the United Nations Convention on the Law of the Sea, can regulate the high seas and can provide answers to the identified challenges for the governance of these technologies. And then, based on the limitations of the regulatory framework, I will propose 3 alternatives that could strengthen the framework to govern this climate change mitigation activity. So with this plan, I start with the regulatory framework. So the first, so we have a very fragmented and sectorial framework for the governance of activities in areas beyond national jurisdiction. We have a framework convention, as I said, the United Nations Convention of the Law of the Sea, and I highlighted the different parts that are relevant for this paper, which are the CBD, the Convention on Biological Diversity, and the Regional Seas Conventions that are mainly focused on the protection of the environment. And also part 11 of the agreement of UNCLOS, which regulates the activities in the area, which are governed by the ISA, the International Seabed Authority. But as you can see, there are other many instruments and organizations that are managing the resources in the ocean spaces. So now, if we focus in these technologies in areas beyond national jurisdiction, what we have to say is that UNCLOS provides the main regulatory framework, and together with the CBD. But also, as I said, there are regional sea conventions that have a mandate in areas beyond national jurisdiction, and therefore are part of the framework. Here there is an example of the OSPAR and the Barcelona Conventions that they respectively apply in the Northeast Atlantic and the Mediterranean Sea. So now we move to the key legal challenges for the development of these technologies in the high seas, and the first is related to security. The development of marine renewable energy technologies can create conflicts for the use of space. Why? Because states do not have sovereignty or jurisdiction over these spaces, and they can only be regulated through international law. In this regard, we have to remember that this is not like navigation, for example, that they need to occupy the space in perpetuity, or at least for 20, 30 years until the decommission. And the second is that there are frequent environmental costs associated to the use of these technologies. Some of them, there is no consensus about all the impacts, but they all the studies refer to habitat loss of marine wildlife, collision risks, killing of fish through direct blade strikes, underwater noise, electromagnetic effects, vibration effects. There are many effects associated to the use of these technologies in the marine ecosystems. In this regard, I'm using this picture because I think it represents that all the life that we can find in areas beyond national jurisdictions in the high seas. People seem to think that this is a vacuum and there is no life, but this, actually the contrary. And it's also critical for the climate system and for us and for the oxygen that we need for breathing. This leads us to the third part, which is the legal analysis of the UNCLOS and how UNCLOS can provide answers to these key challenges, and how these technologies are regulated under international law. So as I said, I'm providing here the preliminary conclusions on the limitations that I have found under UNCLOS. The first thing that we have to say is that the area is governed by the principle of common heritage of mankind, and this is governed by the ISA, the International Seabed Authority, which regulates the activities in the area. These are mainly minerals. Therefore, it's questionable if the mandate of the ISA can be extended to marine renewable energy technologies. On the other hand, we have the principle of the freedom of the high seas, that in principle, there is no provision for the development of these technologies in the high seas, but it's insufficient in the development and the regulation of the restricted freedoms of the high seas. There is a numerous apertures of freedoms of the high seas, but the conventions includes these 7 that I'm including in this presentation, and I'm highlighting 2 of them: freedom to lay submarine cables and pipelines, which is relevant for the transmission of energy from the installations to the grid, and the freedom to construct artificial islands and other installations permitted under international law, which can be applied to marine renewable energy technologies. Also, there are no mechanism to establish area-based management tools such as maritime spatial planning. In this regard, maritime spatial planning, it's useful to coordinate activities in a space, and we use this, for example, in the EU, member states have to implement the Maritime Spatial Planning Directive, and this helps to contribute to avoid conflicts in the use of the space. However, we can unilaterally manage the space through these tools in the high seas, and therefore we cannot avoid conflicts through the use of this tool. Also, Part 12 of UNCLOS, which is dedicated to the protection of the marine environment, only offers minimum standards of protection. That said, it includes the environmental impact assessment requirement in Article 206, which is essential. It's an essential obligation since it determines or contributes to determine where and when, whether the deployment of these technologies should be allowed in a specific location. In any case, there is no uniform environmental impact assessment requirement, and this needs to be further developed. So, if we go to the legal constraints in the exercise of the freedom of the high seas, if we focus more on the freedoms of the high seas and on these 2 specific freedoms that I was talking about, there are these challenges related to the management of space in the high seas, since all states have equal rights to the use of the high seas, but the principle of freedom does not permit management, as I was saying before. We cannot use maritime spatial planning, for example, or for example, the use of marine protected areas is limited to certain spaces. Also, we have legal challenges regarding the mechanisms for the dispute settlement in the exercise of the freedom of the high seas. For sure, all UNCLOS provides different mechanisms, but it doesn't establish how to proceed in case there is a collision in the exercise of the freedoms by 2 or more states. Therefore, the conclusions that we can draw from the analysis is that the UNCLOS has important limitations to guarantee the secure and sustainable development of this industry in the high seas, and we need a specific regulation and governing structures to avoid conflicts and ensure the compliance of UNCLOS. While I say this, it's also important to bear in mind that we have the figure or the environmental, the obligation to carry out environmental impact assessment and the Article 206 of UNCLOS, and this needs to be further developed. And we are having the opportunity through the BBNJ negotiations, the Biodiversity Beyond National Jurisdiction negotiations, that I will talk about them a bit later. So this leads us to exploring. We have identified these two legal challenges and how UNCLOS provides limitations to regulate marine renewable energies in these spaces.
And in your last minute.
I'm in my last minute. So there are three, I'm exploring three possibilities. Regulating these technologies under the respected BBNJ treaty, or the regional sea conventions with mandate in RSPG national jurisdiction, or through energy agencies. I will go very quickly. So we have these three possibilities, and specifically, this BBNJ treaty provides the possibility to further develop the EIA regulation, plus also the maritime special planning and the marine protected areas. We also have the possibility to regulate through the regional sea conventions that I was mentioning before, that have a mandate in RSPG national jurisdiction. And the third possibility is that I'm exploring is regulating them through the energy agencies. And specifically, I'm indicating the International Renewable Energy Agency, IRENA, and the International Energy Agency. So this is a summary of what I just said. There are two main problems related with the use of marine renewable energies in the high seas, which are related to the security and the protection of the environment. UNCLOS show limitations for the reasons I mentioned, and I provide or I explore three possibilities for the regulation of these technologies in the high seas. The regulation through the BBNJ treaty, through the regional sea conventions with mandate in the high seas, and through the energy agencies. And the last key message is that a specific regulation for the deployment of these technologies, as well as governing structures, seem to be necessary. Otherwise, the deployment of these technologies in the high seas could pose a significant challenge to the exercise of the freedoms of the high seas, which might entail international security and environmental concerns if not taken in advance. Thank you for your attention.
Thank you very much as well. And I would like to especially thank you for keeping almost to time, 1 minute over. And I will remind all panelists to make certain to be very strict with time so as not to steal minutes from others. But I think this was a fascinating and very well-researched presentation. And I would like to already invite for both of the first two extremely interesting and rich presentations, if the audience who was with us, and I'm so glad to see so many of you online, would like to put questions into the Q&A function of the chat, we will be able to take your questions in a moderated way as soon as the panelists have completed their first presentations. So please do, if you have comments on either the international criminal law, Ecocide implications, or the marine renewable technologies, place your questions already in the chat. And Professor Anand, Dr. Carlos, if you wish to answer already as well by typing, that is absolutely fine. And we will still come to you with the question orally. I will now introduce Thiago Pires Oliveira, who is a Ph.D. candidate at the University of Sao Paulo, and Dr. Tagore Trajano de Almeida Silva, who is a professor at the Catholic University of Salvador. And they have a fascinating presentation on the proposals for regulation of methane emissions as a turning point of global climate governance, a socio-legal approach. And I will ask you as well to keep your remarks to 14 minutes so that we can catch up a little bit on our time. Thank you.
Thank you so much. Thank you for everyone. It's a pleasure to be here in an International Student Cambridge Conference. I'm talking from Brazil, and I present this movement. Thiago and I have studied this topic for such a long time. You have, if you see, you have 3 reviews here in Brazil in 2 universities that talk about this topic. One of the review in the last year is qualified, or the best review, the Brazilian review about this topic as animal law, environmental law, and natural rights reviews in Brazil. So I have to say thank you for my universities the Federal University of Bahia and the Catholic University of Salvador for all help to be here. And not just this, you need to talk about what happened in Brazil. This is the topic of our article, our paper. You talk about the historic period in Brazil and some concern that you have now. If you see in 1992, you hold one of the most largest conference in the world called the United Nations Environmental Law Conference in Rio de Janeiro. And that time we tried to organize a budget for the new period that is almost came from that time. And you highlight in that time, the Brazilians highlighted some of the principal concerns that you have about climate change, not about climate change, but about environmental issues. And in our history, you have some concern that you need to focus, that you need to talk, but to understand what happened in Brazil now. So, you know, I don't know if everybody knows, but the Brazilian in 100 years ago, almost 200 years in this year, you had a Brazilian monarchy, and our governance changed so much from that time to now. And if you see in the last highlight there, Brazil, Spain, in Brazilian Constitution, you start to organize a new field that needs to protect our environmental resource. And not just this, try to organize an evolution of laws that in 2009 made it the Climate Change Act took place in Brazil. And this law in 2009, the Climate Change Policy Law in 2009, is a kind of evolution of our legislation here in Brazil. This tries to show some concerns, some debates that you need to talk, you need some help to understand what the next step for our professors and students in our universities. So one of these, this is the title of our paper, is the impact of the methane emissions of climate change as environmental concern. And that when Thiago and I wrote this paper, you need to establish or try to establish a global regulation about this kind of economic activity that impact the climate, require decision makers to build a kind of consensus in the international law, and try to organize what does mean the greenhouse gas, and what kind of development that you can countries such as Brazil can be responsible in this new center. So it's like I make a comparison between Brazil and the US about how you have replacing beef with plants. If you see in the next, probably in the early past time, you can say that anthropogenic methane emission in Brazil has distributed as manure management, rice cultivation, soya beans, and corn beans. In most of these agriculture here have been distributed, have been delivered for the beef production. So it's like if you see I put here, the Latin America is one of the largest place that use beef as a dairy, and had used our soil, our forest and our water to produce this industry. So it's like what kind of this industry, what that impact of this industry for the climate change nowadays, and not just this, what kind of a problem is that the agriculture greenhouse gas has provided for the world. And I brought here, if you see, you can see here China and India, but the Brazil is the second largest industry in the world that use beef, use animals, raise of livestock had disproportionality here in Brazil. And if you see, most of our soils in our territory have been used for this industry. I brought here the Brazilian map, and if you see in your left side, you can see the Amazon part of Brazil is the largest part that you have in our territory. And if you see, you have like such countries as Peru, Bolivia, that use these cattle heads, these agriculture animals in his soil. But if you see, Brazil have increased his produce in this part of our territory. So if you see regions such as Mato Grosso, Rondônia, Acre, Tocantins, this in the 10 years ago, this part of Brazil is, you can find a forest such as Amazon and Pantanal. But now, if you see in the right side, in another picture, you can see that you can find inside the Amazon forest a big cattle. That means that you can produce and use so much these lands for the agriculture, the cattle industry. So it's like, yeah, this is one of our concerns. As I said, the world's second largest producer in beef is Brazil. The emission, this is one of the parts of our article. The emission due to deforestation for the open a new pasture is one of the most concern that the largest concern that you have. If you see the huge cattle in 2017 in the central east Brazil, this region start to have a dry period, because there is no rain in this part of the period, because you cut off the forest and introduce new pastures and produce a larger part of the destruction of the Amazon. The deforestation of this forest is not just for cattle, but there is the soil, the soybeans, and the corn production, and this industry impacts so much in the development of the forest. I put here the Brazilian political division just to say that in Brazil, all of our political administrative organization can make law about the environmental issues. If you see in the map, you can compare this map with the cattle one, that one. If you see that the green one, that the Amazon part of Brazil, start to be a new border of this industry. So it's like what our concern now, that you brought in our paper, is the green economy, and you need to develop a new possibilities for this issue. In the past, the most problems in the Amazon part is the energy, about the hydraulic power. You needed to build some you need to use the power of the rivers in this part of our territory. So it's like it's in the past, but now the hugest problem is the deforestation. With our new president, Bolsonaro, you had, if you see in the right part, you can see two parts of the pictures. You can see the forest, the whole forest, but if you see in the other side, you see the agriculture. This affects so much the indigenous people. If you see in the map, in the top of Brazil, you can find the state of Roraima. In this state, there is a huge, one of the largest concern, the social movement concern, the indigenous social movement concern about the territory of the indigenous. You need to argue for wide ecological diversity. In the Supreme Brazilian Court said that you need to preserve this part. So another one, as I said, is the surface water. That like in the 10 years ago, 5 years ago, this is the hugest problem that you can have there. But nowadays, you start to focus on another problem. One of these is the poverty. If you don't have a forest, if you produce and destroy your soil, the question is, the Brazilian people increase your development, increase your potable water, and the problems that you had here? And the answer is not. So it's like in the last 2 years, you can find so much deforestation, increase of the agriculture and livestock production. The Brazilian is one of the most largest illegal commerce of wildlife animals, and this pandemic time made us organize a question in our mind: is what the next, probably you can find in Brazil the next.
And this is your last question, right?
Yeah. The next problem that you have. This is one that challenge that you, as I said, that you had. And I have to say thank you so much for being here and bring some concern that you have here in Brazil. Thank you.
Thank you very much for that fascinating case study. Without further ado, I will pass to a colleague who needs no introduction. We worked extremely well with him as a privilege in his collaborations for the COP26. And it is, of course, Danilo Garrido Alves, who is a PhD candidate at the University of Oxford, and will have a presentation on the analogy between corporations and international organizations towards a new UNGP-based approach in studying global governance. Danilo, the floor is yours.
Thank you very much, Professor Cordonier Segger. And hello to everyone present. Just to confirm, can you see my screen?
Yes, all is well.
Great. So from the topic of my presentation, you might wonder what I'm doing talking in a climate / environmental panel. And I think this was a masterful thing that the organizers did, because the idea of this paper is really to break silos of various disciplines. So the focus of my project is in international organizations, specifically development banks, and more specifically their development projects. But I'm getting ahead of myself. The structure of the presentation is as follows. First, I'll just give a general overview of the project that I'm conducting now, which is my PhD project. Then I'll talk about the main approaches currently existing to the law of international organizations and the issues that I find with them, especially from the point of view of accountability. And finally, I will present my ideas, which is to treat IOs also as corporate actors and the business and human rights approach. So as I was talking in the beginning, the overall project talks about business, human rights, and multilateral development banks. MDBs, they are essentially this type of international organization whose main function or main mission is to promote development in the world. Some of them have express mentions to sustainable development. Some of them do not have that express mention. This is something that I tackle in other chapters of the PhD, but as a general thing, they will lend money to states or to corporations so that they can implement projects at the local level, either infrastructure projects or educational projects to improve their socioeconomic and environmental development. The big thing that I want to focus here, just to give a broad overview, is the accountability gap that exists in development financing. So to make it very clear, the picture that you can see is from the Tata Mundra power plant in India, which was financed by the World Bank's IFC. It's the branch of the World Bank that lends money to corporations. And the corporation Tata Mundra, they implemented the project, they created this power plant, but in the process, it occurred a number of environmental harm and a number of human rights violations, including the relocation of communities, the loss of their livelihoods, contamination of local rivers. So, and then the big issue here is that because the funding came from an international organization, the World Bank, and because international organizations generally have immunity before domestic courts, the amount of remedy, especially judicial remedy, that victims or impacted persons can have is very limited, which is why those institutions created these independent accountability mechanisms, which they function almost like grievance mechanisms or ombudspersons, or even compliance mechanisms to try to give some response to those complainants. I will not go into detail on this. This is the focus of my PhD, but for the current presentation, I'm focusing on the first chapter, which is the more theoretical approach that I think is missing in the discussion, which I try to articulate this business and human rights approach to the law of international organizations. I just put the chapter breakdown here so you can see it's part of a bigger picture, but I'll not go into detail so as not to bore you to death. But going to the main part of the presentation, I think it's just worth talking first about the main approaches that currently exist in the law of international organizations. I'm focusing on the legal approaches, not on the international relations or political science approaches. And the reason for that is I'm concerned with accountability and accountability for human rights violations. I'm not concerned with power, imbalances, or how those organizations function in the international system. So the first approach, the legal approach, is functionalism. It's the more traditional one, and it essentially tries to articulate that international organizations should have the rights and privileges that are necessary for it to perform the functions they were created to pursue. This is the more traditional one, as I said, was especially articulated in the post-World War II period, when there was this notion that multilateralism was the answer for everything, and that international organizations could not possibly cause any harm to human rights or to the environment. And the consequence of this is that issues of accountability simply were not present in this discussion. Then more recently, from the early 2000s to the 2010s, this group of scholars created this doctrine, which is global administrative law, which essentially tries to understand that IOs need constraints, and they try to create those constraints based on domestic administrative law and rule of law principles. The main criticism for this approach is that it's very Western-centric. It's the domestic administrative law of, the West, essentially. So it's not truly international or truly global in its core, even though it is concerned with accountability. And finally, the third approach that I would mention is the putative constitutionalization of international law, which is not as relevant, but what they're trying to do here is interesting. So they are essentially saying that all international actors, including international organizations, they must observe this constitution of the international community. It is unclear what this constitution of the international community is. Some of them argue that the UN Charter is the constitution. Some of them argue that Jus is the constitution, or the United Nations, the Universal Declaration of Human Rights would be a part of this constitution. But the general idea is that there will be some norms that would regulate the entirety of the legal scope, of the legal landscape, of the international community, and this would be analogous to a domestic constitution. What I think is the main issue, especially when we're thinking of development projects and the multilateral development banks, can be flagged in three different points. The first is that all of the legal approaches to the law of IOs, they tend to over-rely in analogies to states. It is a widely recognized limitation of the field, because international organizations are seen, they are international legal persons, and the international legal person per se are states. So it's easier to make those sort of analogies. But I think there's something missing here, especially when the mission of the international organization is much closer to the operation of corporations or banks than to the traditional functions of a state. The second issue that I find with those approaches is that all of them lack a grounding instrument. This is less so in the putative constitutionalization, but there is no single document that everyone can agree that really is the cornerstone of the approach. They are essentially theoretical. And the final point, the final issue, is that I do not think that any of them really give enough focus to accountability towards individuals that are affected by an IO. Global administrative law is better at this point, but I still think it's much more concerned with the internal structures of an organization than to the impacts that an organization can have in individuals, in communities, in the environment. So with this in mind, we go to my main argument, which the first part is that IOs should also be seen as corporate actors. But first, a step back. So just IOs, they are functional entities. It's important to have this in mind. They are created by states or by states and other international organizations with very specific missions, either to set standards, to protect human rights, to protect the environment, to regulate aviation. They have very narrow scopes. And in doing so, they are created to assist states to meet the obligations of the states and also coordinate competing interests. So they have a dual role in their functioning. But what is often missing is that they do not always act as international legal persons. So for instance, the UN, when it's in the US, where its secretariat is based, it will also have to hire paper supplier, contract with paper suppliers, or hire cleaning services. Those more day-to-day mundane activities, they are regulated by domestic law, and they would not have the same sort of prerogatives in those dealings than they would, for instance, when they are sending peacekeeping missions to an area of conflict. And I think the focus on states in the theorization of the law of international organizations and the focus on the international legal person aspect has really overshadowed this other dimension of international organizations that, regardless of what their legal nature under international law is, they do at times function as corporations or as private actors. And if we can agree on that, then my later argument might be easier to swallow, which is that sometimes even when they are directly pursuing their missions, even when they are acting as international legal persons, they might also be functioning as corporations or private actors. And for instance, if you recall the example that I gave in the beginning of the presentation, the IFC, an international organization, it contracted directly with this company, Tata Mundra, which was a corporation, to carry out the development project. And I see Professor Cordonier Segger on the screen, which means I need to run to finish. And just finally on the business human rights approach, what is it? What is this thing that I think we should do? So it's complementary to the other approaches. So it focuses on a different side of IOs that is not really being explored. So it does not try to say that everyone's wrong. It's just looking at a different angle. Its focus is on universally recognized human rights principles rather than, a Western administrative law such as global governance, global administrative law. Apologies. It is functional in essence, but not like functionalism. So it understands that the specific functions of certain IOs would give rise to specific responsibilities. And an example is, if you set an accountability mechanism, you must ensure that this mechanism follows certain international standards for effective remedy, for non-repetition, etc. And it has a grounding instrument, which is the United Nations Guiding Principles on Business and Human Rights, or UNGPs. There's a little issue with this, is that the UNGPs, they do not expressly mention IOs, only states and corporations, but the UN in the OHCHR, the UN Working Group, and even some of the multilateral development banks, they have already expressly mentioned this document, especially Pillar 3 of the Guiding Principles, which focuses on remedy. So the business human rights approach is already affecting the practice of international organizations and of multilateral development banks. And I'll leave the conclusions on the screen so as not to take much more time, but thank you very much for your attention.
Very well done. Thank you. And I know that you are racing to conclude with many very interesting discoveries in your research to date, and I'm sure more to come. I will link also that I've seen Danilo's work as being particularly key for some of the net zero commitments that some of our different international financial institutions have taken on. So while he is a nod to breaking down the pillars and to considering things from different points of view, I think he is also in his research doing work which, given the human right to a clean and healthy environment, is going to be particularly key for action on climate change. Thank you, Danilo. I will now turn directly to Ju-Ching Huang, who is an S.J.D. candidate at the Georgetown University Law Center. And this presentation is on framing the future global adaptation law regime, principles for emerging dynamics of climate change governance, which is of course particularly relevant as we prepare for the next COP in Sharm el-Sheikh. So thank you very much, Ms. Huang. Please go ahead.
Thank you, Professor. Hi, everyone. It's a great pleasure to be here. Let me just first share my screen as well. See if that works. Okay. Can everyone see my screen right now? I'm going to.
Yes, we can.
Okay. Great. So my topic today is about framing the future of global adaptation, law Ju-Ching. And I'll be talking about, let's see how do I do this? Okay, here we go. Yeah, so a quick roadmap from my today's presentation. First, I will talk about what is adaptation and why it is important to have multi-level adaptation governance and relevant to global governance, and seeing the trend in the dynamics of globalizing happening, especially using finance as our case study, and then start to, from there, thinking about what are the necessary and related international law principles and norms that could be particularly helpful for our future adaptation law regime. So what is adaptation? And we have in this panel this morning, we have listened to about greenhouse gas emissions, mitigations, renewable energies, and all these related to how do we reduce the emissions mitigation side of the issues. And it's kind of clear that it's related to global issues, right? So let's come back a bit, like thinking about the disasters happening and extreme weathers. And as you can see from this picture, there are floodings, extreme weathers, wildfires. There are many definitions. And here I'm using the definitions of the most updated and just released in this February, I think it's February 28th assessment report by IPCC. So adaptation is defined in human system as the process of adjustment to actual or expected climate and its effects in order to moderate harm or take advantage of beneficial opportunities. So what is that exactly that means? So basically thinking about it in our real life, if there's a flood, what is the government going to do about it? Building the seawall, or basically just elevating the houses, or changing the building codes to make it more strict, and or just move the people to inland, right? So those are all adaptation measures. So in the case of wildfire, you can think of building more monitoring system, a better warning system, and so on to monitor all these things, right? All these kind of natural changing weathers. So you might think adaptation is really like technical and engineer issues. It has nothing to do with probably law or probably with governance, but it has a lot. So first of all, it has to deal with, it needs you need the resources, you need the funding, you need the personnel and the staff to do all these things. And it's like societal support. And also, you might think this is solely local. It's something that basically the communities, the local government, the city governments, or just the state, like national governments, should deal with these issues. Why that matter in a global scale, right? But think about it. It's more than that. It's like something you have to think about the public good, right? Food security, climate sensitive infectious diseases. Those are actually global scale issues, and you can think of transboundary river basins, low-lying coastlines. All these issues are cross boundaries and should be dealt with at the global scale, and it's not just the local problems. And here we go. So it is and it just stays the stage for thinking about what should be done in adaptation governance, right? So in the past, like Danilo has briefly mentioned, that mostly is focusing on the states in the global governance. In a more classical situation or governance, thinking about mitigation policies in climate change policies, it's usually like centralized, consensus-based, top-down decision-making approach. The UN or UNFCCC makes the decisions, and then countries and the parties follows, right? But you can see that has been changing. So here's just a quick image. So you can see that the top-down approach from the global, regional, national, and then subnational actors coming in. That's the level of governance. And now we're looking at probably a better approach, or is happening the dynamics, especially in international environmental law regime, that is getting diversified, decentralized decision-making system. And some scholars have mentioned it as polycentric kind of governance. But most of the conversation and discussion, while saying about climate change governance, is mainly talking about mitigation governance. But here we want to focus on the concept of global adaptation governance also have these dynamics going on of a more bottom-up or polycentric governing approach. So in this paper, I focus on the direct cooperation and interaction between these two actors, as you can see here. So one is the intergovernmental organizations. Thank you, Danilo, again, for having that structure before me, presented before me. So I don't have to explain more, but it's kind of like getting a step further, not just the international organizations, but here I'm more focusing on intergovernmental organizations like UNGP, World Bank, adaptation funds, green climate funds, and so on. And how that relates to subnational actors, cities, right? I'm also putting on ECLA and C40s and so on because I want to discuss this. So there's also a trend of globalized local adaptation governance. Again, a lot of scholars have argued that adaptation is such a local issue, and there's like it's contested concept of having a global adaptation governance here. But we can also see just how clearly that has been changing in the past 10 years or so, even more longer, right? So they're like these subnational actors, urban cities, they have coalitions, they have allied together and then trying to get helped among themselves or with a direct connection with the global actors. They want to get the help like internationalized to obtain funding, especially from IGOs directly. And not, more than that, they can also get the resources and also other key things from the intergovernmental organizations. So you can see that these local governments, they might thinking about getting the help outside of their states. Like you can see that kind of leapfrogging the national and regional level, and then thinking of and getting the help or exchange ideas and sharing their skills with the global actors. And this leads me to the next question about, or the dynamics has been seen in recent years. And that is actually not just globalized. Globalized seems to be like a one direction, right? The subnational going globalized, but here it's more. We're seeing a globalized adaptation governance, and I'm using finance as a example. But before going there, we think about globalization mostly in other contexts, right? Less about in these adaptation governance contexts. So the idea of globalization means the process that connects the local to the global. The global to the local. So you can see that kind of multi-directional and allow the city and international actors to interact with each other and influence each other. So this definition is clear and it shows that it is not one direction, but it's like two multi-direction. And using adaptation fund as an example. So the reason I'm using finance as an example in adaptation governance is because it's kind of the key in making adaptation works, especially it's very practical, right? Because adaptation in a way is not, it requires a lot of funding, personnel and resources, and even skills, techniques, and so on. And so finance is definitely one of the key elements in adaptation governance that we cannot ignore. So using adaptation fund as an example is because it's kind of the closest to what I wanted to share here, because it's a direct link between the intergovernmental organizations and local governments. is mainly funded. So first of all, how it is get funding, right? So the first is that it's funded through a share of the proceeds from the transactions of the Clean Development Mechanism, the CDM, and complemented by voluntary contributions. So here comes the first features that's related to my research. That is the voluntary contributions. So the funding is not coming like obligatory from a bunch of members. It's voluntary. And these voluntary contributions is not only coming from states, it can also coming from the subnational actors, right? So in 2013, like Brussels capital region of Belgium itself has contributed $1.59 million. So it's not just the states that can contribute. It can also be other subnational actors. In this case, it shows that these subnational government entities can donate and deepens the linkage between these local governance and the international organization. And then the second feature is direct access that adaptation funds has been promoting for the past 10 years. This is something that they're trying to do very hard. And I also want to just respond to what Danilo is saying about development bank. Here, the adaptation funds, what they're trying to do in their direct access process is they're sort of skipping the multi-development bank process in order to funnel the money or the funding to the local communities who need it the most. They're trying to get through the fund in an international level and then fund it directly to the local communities. However, there's still they still need the national level still need a national implementing entities and then executive entities. That's the subnational cities or local communities who's actually receiving those monies and make adaptation work like nature-based solutions and so on. So but what they're trying to do and they are promoting is instead of going to multiple hurdles, they can get to the one who need it most. And that's kind of the idea in this paper as well, aiming toward a rather localized funding process that can better be tailored to the local community's urgent needs. And from their past observation and research, adaptation funds have also found that these direct access has actually included more public participation than before. Right. So having those contexts in mind, now I'm shifting gears to looking in a broader picture of using these as a quick example, showing what are the related principles and norms. So you might think there are already international environmental law principles, and why are we discussing here these again? Because as I'm going through all the scholarship, most of them are dealing with climate change, but mostly about mitigation again, even in international principles and norms. So what in my paper is trying to figure out is whether there are some key principles and norms that are related and especially helpful in our future adaptation law regime. Because we already know, there is the need for this governance and there needs to be a very clear principles and norms. So here are the first sets of principles that I think is very key to adaptation law governance. First is the norm of cooperation, and then the equity, and then the implementing common but differentiated responsibilities. So the reason I am grouping them together because they are very connected, and then you can see it as one set of tools. Cooperation, it's very clear. It can be found in 3 primary international laws in climate change regime, right? UNFCCC, Kyoto Protocol, and 2015 Paris Agreement that the professor just mentioned in the beginning of our panel, right? So that's the key documents that all address the importance of cooperation between the states. And then the equity issues, that's without doubt, that's something, a non-discriminatory norm calling for the absence of systematic disparities in accessing natural resources, basic goods, and essential services. Now I want to focus on how these 2 norms getting into implementing norms. That is the common but differentiate responsibilities. Usually we heard this term in the context, again, in mitigation, right? Who should be paying more to deal with mitigation, the emissions of greenhouse gases. Here, I want to further elaborate on these. These common but differentiate
responsibilities.
Okay, right. So yes, so this is like the state should, who have not just the states, but illustrate more is like how these subnational actors who are more like who have more ability to deal with the issues that shoulders more, and helping those who needs more or who are the most vulnerable in this sense. And then very quickly, the second set of international norms and principles I want to address here, again, is accountability, but more than just accountability, it is a mutual accountability I want to address here, that it's not just one direction, who is receiving it, and they should also be accountable for who is distributing it. Right? So these kind of dynamics must be addressed, especially when finance is the key in adaptation law. And transparency is just a supplement, like the key of the fundamental key for having that mutual accountability norms in order to happen. So these quickly wraps up for concludes to my research. So you can see in, especially in global adaptation governance, there is a localized trend. And local governments as contributors and receivers of global monetary and technology support, they go hand in hand, and they need these more than ever. And local solutions will need the global help. So it's not just like adaptations we don't have to carry in the global sphere, but the opposite. We need the global spheres to come together and coordinate and to help local governments in the future. Thank you for listening. That ends my presentation.
Very much. And thank you especially for your discipline. Indeed, thank you to all of our panelists for your discipline, which allows us to then have an actual discussion of some of your work and to give you an opportunity to give your views. Now, we have several questions in the Q&A that have come up, and I think some of you have been diligently answering those questions as well by typing responses. But what I would like to do is to turn to our team from the conference and ask them if they would be able to signal a few of the questions from the Q&A, maybe one that addresses each of your presentations, for example. Before I do that, I do want to give you a chance to ask each other questions. You know, Danilo underlined, and each of you have referred to the need to take into account each other's views and work and to bridge those silos. So do any of you have a question for each other on your presentation? You are all very passionate about the work you're doing. And of course, it is hard to stay in 15 minutes when you could talk for hours about your topic. But at least giving you a chance to ask each other questions. I will maybe take 3 from you to each other and then open it up to a general set of questions through our Zoom moderators. Danilo, go ahead.
Thank you. Well, I think I of course want to ask several questions to Ju-Ching. I think, yeah, your work's fascinating and so many synergies, but I'll be considerate of the others and just ask if you could talk a little bit more about how this mutual accountability idea functions, because I think that's an interesting concept, the 2 ways, and yeah, especially in the context of this direct access. So yeah, I would, yeah, thank you.
Absolutely, Danilo. And indeed, some of the studies we've done in Africa have shown that companies are paying for adaptation, greatly investing in it, but just don't count it as adaptation. It's called shoring up the hotel before it goes under, you know, in order to keep business going. And maybe just one other question or 2 other questions from a panelist to another panelist. Carlos and Santosh, you were very much on time, and you also, I'm sure, listened with interest to your fellow panelists. Do either of you have a question for another panelist? Go ahead.
Well, I have a question regarding the Ecocide. How do you think it can be improved, and how can this we have a progress on the definition of Ecocide? How do you think that this can be improved? And if with the current definition, can we link these to other concepts or principles to strengthen the definition? Thank you.
Excellent. Yes, thank you. I think I may have written something on this at some point in my life. Now let me see. Are there one other question? If not, I'm going to abuse my position as chair and ask Danilo if he can especially give us any ideas about how the international organizations he's looking at could particularly address the human right to a clean environment as recognized through the work of David Boyd and others just recently in the UN, and then also, of course, net zero commitments on climate change. I think we will take them in order. So maybe let's go in reverse order out of kindness to our presenters who started and kept on time at the very beginning. Maybe Professor Anand, Mr. Santosh Anand, would you like to first answer about Ecocide, and then
Yes.
and then we'll go to Danilo, and then we'll go to Ju-Ching.
Yeah, thank you for the question. So yes, there are scopes for improvement of the proposed definition, but then there has to be like appreciation of the context here. And the context of this definition is that anyway, the practical value of this definition was not going to be anything in terms of substantive progress, even by the terms on which the expert panel has proposed this definition. What they were looking for is a symbolic value with this definition and inclusion of a new crime. But then on that symbolic value front also, which is the expressive function of international criminal law, because anyway, one single institution, howsoever well-funded, which it is not, cannot sort of prosecute large number of crimes and cases across the world. So in many ways, the function of International Criminal Court has been described as that of performing an expressive function, sort of indicating and propagating the value underlying specific norms which prohibit, different sort of criminal conduct. So now on that count also, this definition fails because of its inclusion of, qualifications like wantonness and privileging of social and economic benefits over protection of environment in an unqualified manner. So on those counts, this definition can definitely be improved if the element of wantonness is removed, and even the qualification of unlawful conduct is removed, and we just stick with a severe, widespread or long-term damage to the environment. So that would go a long way in sort of adding value to possible crime of ecocide that would be included, which again, I would reiterate, does not add up to much in terms of practical substantive change that it might possibly bring with respect to addressing ramifications or consequences of climate change, but just for the symbolic value. Yeah.
Very interesting. And of course, one cannot help but think about certain activities right now in Ukraine, very close to nuclear reactors, that have already seen some accidents in the past, and how this definition, as you propose it, would possibly apply. Danilo?
Yes, thank you very much for the great question, Professor Cordonier Segger. That is exactly the question that I'm answering on another chapter of my thesis. So thank you very much for that. So essentially, the way I see it is, even though whenever we look at the literature, it's very unclear the extent of the human rights obligations that those international organizations have. In relation to human rights, and specifically those human rights that have a clear environmental content to them, such as the human rights to a clean, safe, and healthy environment, I think we can get this provision from the articles of agreement of the banks themselves. So essentially the treaties that created them. So the very notion that they are designed to promote development, and we can look that this entails a certain degree of responsibility, of obligation in that regard. Even the earlier ones, when development was understood as an economic concept and not as a sustainable development concept, even those institutions, they have those sort of obligations. This has been clarified by the ICJ in other contexts by saying in Gabčíkovo Nagimaros that the concept of development has grown nowadays to encompass sustainability. So, and because it contains sustainability, it is simply impossible not to think of human rights, and not to think of the human rights specifically to clean and healthy environment in that circumstance. So they have the obligation. How they can actually ensure that they are helping states and fulfill this obligation is by ensuring that the development projects that they are conducting, they carry out in the pre-assessment phase, that they carry out effective human rights due diligence, effective environmental impact assessments, that they are aligned with the general standards on social environmental matters globally. And also in the case that even after on the implementation phase, that certain human rights harms or certain rights violations or environmental harms occur, that they have the tools to hear those complaints and to give an adequate response to redress. So hope that answers.
Yeah, absolutely. And actually in the International Law Association's new guidelines on sustainable management of natural resources, this is one of the elements that we highlight as a potential way forward. Back to Ju-Ching with a question from your fellow panelist.
Yes, so so the idea is to respond to Danilo's question about mutual accountability. I think that's also a very fascinating concept when I'm doing this research. So I think this is proposed by Professor Edith Brown-Wise, that she emphasized that accountability is often a dynamic process in which change takes place during the process of accountability. So that's kind of what she has mentioned previously. And because she previously working at the World Bank and leading on the accountability board of executive directors and approving the projects. And she's specifically using that project cycle of 4 phases of accountability: the planning, implementation, evaluation, and learning phases. And through those research, one example from that mutual accountability between the people that might be affected by the funded projects in the World Bank. And here she's trying to say it's a two-side accountability. So one is, how do we hold accountability of the World Bank? It's not just the World Banks who decided the project, that like the board should ensure that the project is appropriate for the local community. But here, the local communities, these people are also implicitly accountable for raising real claims and not for using the situation to advance personal or political ends disguised as complaints about the project. So it's kind of that idea of both sides are held accountable. And to use this principle in the example of adaptation governance in adaptation fund itself, the direct assets here, I found they have two-step accountability mechanism. So the first is implementing the entity's grievance mechanisms. So if the parties fail to agree on mutually satisfying outcome, and then they will go to the second step of ad hoc complaint handling mechanisms. But those complaint mechanisms are still sort of like the more classical or typical idea of accountability. And here's that what I'm trying to research now, so thank you for raising that, is how we can ensure that the people, again, going back to the center idea of how can you make sure those most vulnerables get the help, but not getting into like building a resort on the coastline, and that's called adaptation. We don't know why, but like, so yes, so thank you for raising that question. I would love to talk with you more later. Thank you.
Excellent. It sounds like our panel is going to result in a new definition of accountability, which is a good start in terms of where international law needs to go in this area. Now, I can see that Thiago has his hand raised. What I'm going to do, I'm going to turn to Tuba and ask her if she could share with us a few questions that have come through the audience that have stayed with us very patiently and very engaged. And then we will come around, and Thiago, we will end with you, and you can also ask if you have a question for others while you answer what is on the chat for you. So so Tuba, would you like to go ahead? Ideally, you have 5 questions lined up, one for each panelist, but if you want to sneak in a couple of extra ones, that's fine.
Yes, thank you so much. It was indeed a very insightful panel. I'll start taking questions in order, and I'll address them if they're specifically mentioned to one of our panelists. So the first one is from George Darlington Hashaka from Kampala, Uganda Peace Foundation, and the question is to Mr. Anand. Just as it is imperative to criminalize environmental damage, isn't it necessary to institute a carbon tax law for greenhouse gas emitters?
Okay, can you also ask the other 4 so that our other panelists can start to prepare their ideas and their answers,
Sure.
even as Santosh is answering a question about market-based mechanisms when he's a criminal lawyer. And if there's a second question for Santosh, that would actually also be probably quite kind.
Yes, there are actually, I think, 2 more to Mr. Santosh. So I think, yes, I'll ask all of them. So the next one is from Georgi Bedze, who's an LLM candidate from University of Glasgow. And the question again is to Mr. Anand. Do you think the addition of the proposed crime of ecocide to Rome Statute can have any practical mitigating impact on climate change, given that the majority polluters, China, Russia, India, US, are out of court's reach, and the Rome Statute does not envisage the procedural tools to prosecute corporations, which are key contributors of peacetime ecocide, apart from a theoretical possibility of applying superior responsibility clause, Article 28 to corporate CEOs. Having these constraints in mind, what do you think will be the added value of adopting the crime of ecocide in the Rome Statute? That's the other one. Then there is a question from Mohammad Ghobashi from Alexandria University, Egypt. And the question is not addressed to anyone, so I think anybody can step in and take a go ahead and answer the question. It's about the role of Paris Agreement and its conferences of parties in developing the international law concerning climate and environment, and what to expect from the upcoming COP27 in Egypt. And then there is another question from Edna Leonard M. Tama from Tanzania. And the question is to Ms. Huang. Do you think harmonization of laws to protect shared resources help in the adaptation processes? And then the next question is from Isibor Aikbe Okihanan. I'm extremely sorry for the pronunciation. This question is from Nigeria. How can the most vulnerable seek and obtain protection of the law of their human rights? Again, it's not addressed to anyone specifically, so
I think it probably goes to Danilo, but I think Thiago can also touch on that with the work he's doing on the Amazon.
Yes. There is the next question would be from Eliot Welch. This is for Dr. Carlos. What do you think the implications may be for biodiversity in ABNJ if renewable energy projects on the high seas proliferate in the future? Do you think the proposed UN treaty on the protection of biodiversity beyond national jurisdiction could address these issues either through MPAs or EIA procedures?
Excellent. So that's a good round of first questions. And I know each of you have been taking notes specifically of the ones that are addressed to you or where you could address it. I'm going to come around first to Santosh, and maybe you would have an answer to especially the second question.
Yes. So I think there are overlap between those two questions. And so before, I cannot directly address efficacy of market-based mechanisms, but then I would approach that question from criminal law lens itself. And the point about having crime is to, any fruitful sort of conceptualization of a given category of crime has to be accounted for independent of regulation, in the sense that a useful theorization of a particular crime has to answer two set of questions. First is whether, what are the defining features of a particular crime? So in the case of this proposed definition, yes, that question is answered. But then the second question that needs to be answered is whether for this particular set of crime, that particular, the proposed punishment is necessary, is it required? So in other words, whether these the particular set of conducts need to be criminalized. So that's kind of a question, the answer to which would allow one to judge and evaluate existing provisions of criminal law or proposed provisions of criminal law, independent of what law provides. So in that sense, this proposed definition does not sort of address that second question, why this particular crime should be on the law book. Now, and that's why I don't think even if these largest polluter states were not members of the Rome Statute, or International Criminal Court does not have jurisdiction, I don't know what difference it would have made if these states were in fact members of Rome Statute and we had this definition of ecocide on the Rome Statute, because most of the serious acts of, in terms of volume, damage to the environment would have gone outside the scope of this definition. And that's why the important bit is to redefine and reimagine this particular definition along the lines of corporate liability, which is a very difficult issue when it comes to international criminal law. But then scholars have in fact recommended a polycentric approach when it comes to liability for environmental damage. And this liability would include liability for different categories of actors, like individuals, sure, but legal persons as well, states as well. And the liability would be mostly non-penal. Okay, and penalty would have a place, but then the focus would not be overwhelmingly on penalty. So I hope that addresses the question. Thank you.
Thank you. It is indeed. If an international crime shocks the conscience of humankind, then we need to be able to show that it has that guiding effect on the conscience of humankind. Yes. Thank you. So I'm going to turn to Dr. Carlos Soria Rodriguez next to be able to address his question. Okay,
thank you. Very interesting questions. The first is it's about the ecology and what are the implications for the biodiversity in areas beyond national jurisdiction if renewable energy projects on the high seas proliferate in the future. Well, there are many papers on that, and there can be effects associated to vibrations, electromagnetic effects, and the noise. Also, for the mammals that we can find in the sea, they can alter the routes. Also, there are many studies on how this is altered in the life in there. But in any case, we have to take into account the protection of the environment before doing this, because we can impact on that. So then the second question is, do you think the proposed BBNJ treaty, expected BBNJ treaty, could address these issues either through MPAs, marine protected areas, or EAI, environmental impact assessment procedures? This is the first alternative that I was discussing, and but there are, of course, we can do that. And my suggestions will be to go through these two elements, but we have to bear in mind what others have been talking about the multi-level governance and the regime interaction and how everything works. Now we see the climate change regime that is dealing with ocean matters, the biodiversity regime and the law of the sea regime. We have to see how everything connects between each other and to avoid these problems, and everything has, I was talking about two issues, security and biodiversity, and everything has to be taken into account together. But for sure, we need to further develop the EIA. And with this, what I mean with the EIA is that we have the ESPO Convention, the Kiev Protocol, we have the Article 14 CBD on EAA. We have UNCLOS. So we have a lot of obligations on environmental impact assessment, and for sure we have to see how this works. The same applies with the marine protected areas. There are many systems that we are using to address these problems, and for sure it helps and contributes to identify vulnerable ecosystems and to avoid these places in order to identify which areas are better to construct these renewables. In any case, it's not just MPAs, but other area-based management tools like maritime spatial planning. But as I said in the presentations, we have to see how to govern the high seas and to do this in accordance with UNCLOS and the freedom of the high seas. Thank you for the questions.
Excellent. And thank you for those really quite stimulating answers. I'm going to turn now to Thiago, if you have answers to the questions that were directed to you, and a question for one of your colleagues.
Actually, I wrote down some of the questions that made for me. It's one of the Joseph Frank that asked me about that the political climate in Brazil allow for a real change for meat production. As I said, Brazil, US, China, and India are the top 4 pollution nation and contribute for more than 30% to total the agriculture related for emission, this kind of emission. So this is a problem that you have to face. And our national climate change policy has some initiative to create a kind of national climate protection system that try to address a public pollution politics about how can create to encourage a healthy diet, for example, in public schools in Brazil, better available than meat is one of the examples that you can bring. And another, this kind of international conference, such this one here, make us to understand what kind of debate you need to prioritize in Brazil. This kind of industry, these commodities, or our forest. And the second one that I pick here, it's from Toga, it's from George, that he asked me about how can you control the emission of greenhouse gas without considering the popularize the concept of the 90 planetary boards. And I answered him to say that I don't think so. I think this frame needs to be built together in the international panels. In Brazil, this need to understand the importance that you can have in our forest and in our diversity. So it's like this goal need to, if you follow these goals, the 9 planetary board, as you said, the climate change, the biospheric integrity, you'll be done. So thank you.
Excellent, thank you. And Danilo, anything to add about the questions related to your?
Sure. So just picking up on the question by Isibor, how can the most vulnerable seek and obtain protection for their human rights? I think there are many ways, more specifically in the context that I was talking about, and given that Isibor works at the Central Bank of Nigeria, it would be grievance mechanisms. I think this is a good way that's still quite underdeveloped, especially at the local level. So having the corporations, having the banks, especially those that are involved in activities that harm the environment, that can harm the environment, that can harm human rights. If you have those grievance mechanisms and make sure that they are transparent, that they're independent, they are trustworthy, you could have a good way to ensure that individuals can have their human rights protected without going through all of the issues of courts, and especially, when it's transnational litigation and the costs that are involved. And also NGOs, they're also a good way to ensure that those rights. And yeah, I think those are my 2 cents.
Excellent. And last but certainly not least, Ms. Huang, would you like to just add one quick comment in reply?
Yeah, so thank you for Edna's question. I think this is a very kind of broad question, but I would just use finance as an example. If you can just so you ask how to harmonize to protect shared resources in helping the adaptation process. If you could under the adaptation funding mechanisms, just under UNFCCC, there are global environmental facilities, the adaptation fund, the least developed countries fund, and a special climate fund. So it's kind of getting a little bit notorious that adaptation finance has been a highly fragmented and ill-coordinated aspect of governance. And this is actually a great challenge right now. So how can you pull in all the resources and funnel those to the most needed? That's kind of the challenge that the global governments really have to focus now. It's not just about mitigating the emissions, but thinking about how do we fast, effective, and just in equity of using these resources to the people who need most, like the most vulnerable communities who need most. Thank you.
Thank you. Well, this has been a fascinating panel, and it falls to me to conclude. I'm not going to attempt to draw out all of the links, whether it's on accountability, sustainable exploitation of natural resources in the marine or forest environment, or indeed the criminal penalties that ought to await. I think you've all done an admirable job of joining together the threads of your presentations in this discussion round. What I will say is that despite progress, both internationally in advancing post-Paris ambition and nationally to develop climate responses which respond to all of these pressures and more, there remain clearly critical capacity limitations to effective implementation of international law in this area in a manner that secures the world's SDGs. So these recent international policy, legal, and governance innovations illustrate the relevance of law and governance approaches available. And indeed, we can also look to some of the ongoing litigation, which underlines the importance of access to justice and fair, reliable dispute resolution. But further efforts are necessary to actualize implementation of these commitments on all levels. Effective, accountable international law on sustainable development, especially to address the environment and climate change challenges we face, has never been more important. The enormity of the challenge for the law, and indeed for all governance reform to implement the Paris Agreement commitments, is clear. With 167 UNFCCC parties requiring urgent legal and institutional reform to implement their Paris Agreement commitments and their NDCs, and only a few qualified lawyers available to assist in each country. As discussed in the UNFCCC 26th Conference of the Parties, a capacity chasm is actually gaping in our path ahead. Indeed, in each country and region of the world, hundreds, perhaps thousands of capable, informed jurists specialized in climate change and in sustainable development are desperately needed to bridge this chasm. And I would like to especially remind us that in light of this, the Climate Law and Governance Initiative has taken on, with hundreds of partners at the Glasgow COP, a commitment to go from 600 to 6,000 trained legal specialists in this area over the next 3 years. So essentially, I think we can close with a recognition that as the world prepares to shift gears to implement the Paris rulebook that was agreed in Glasgow, above all, across all fields and professions, the best and the brightest of our law graduates from all countries and from the world's leading centers of legal education and research face a critical opportunity to make a decisive contribution to the highest possible ambition in our global response to climate change and to these broader environmental challenges. We are, of course, joined by 5 of those best and brightest here, together with our CILJ hosts, who I count among that group as well. And I'm very, very, very pleased to welcome you to this field and glad that you are here to travel this path with us. Thank you.